So good day everyone. Today we will be discussing about arrest, search and seizure under Rule 113 of your criminal procedure. So first one, what is an arrest? Okay? An arrest is the taking of a person into custody in order that he may bound to answer for the commission of an offense. This is provided in your Rule 113, Section 1 of your Criminal Procedure of the Rules of Court. So, under this definition po, ang isang tao ay arrested for a specific and definite purpose. And what is that purpose? The purpose is to make him answerable or make him answer for the commission of an offense. So, how do we make an arrest? Paano ba gawin ang isang arrest? Lagi nyo pong tandaan, okay, a person need not be actually restrained by the person making the arrest. Nakalagay po sa Section 2 ng Rule 113. Okay, under the rules of court, a submission to the custody of the person making the arrest already constitutes an arrest. So kahit anong means ang gamitin to make an arrest, ang salitang arrest necessarily implies a control over the person under custody. And as a consequence thereof, merong restraint doon sa liberty niya, doon sa kalayaan niya, to the extent that hindi siya or he is not free to live on his own volition. So tandaan natin, paano ang mag-aresto? Hindi po necessarily na merong actual restraint. Ang nakalagay po sa batas natin, as long as that person under custody is not free to live on his own volition, hindi siya malaya, hindi siya totally malaya, then that makes an arrest. What are the requisites for the issuance of warrant of arrest? Ano yung mga requirements para makapag-issue ng isang warrant of arrest? As provided in your Bill of Rights, particularly your Article 3, Section 2 of your 1987 Philippine Constitution. Nakalagay po dun, okay, no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the person or things to be seized. Lagi nyo pong tandaan dito sa provision ng batas na to. It is a constitutional mandate na makakapag-issue lamang ng warrant of arrest or search warrant kung it was personally determined by the judge. At na-determine niya ito personally after examination under oath or affirmation ng complainant at ang kanyang mga witness. And dapat doon ay naka-describe yung things to be seized o yung person to be arrested. Lagi niyong tandaan na ang isang arrest, ang pag-aresto na walang probable cause is considered to be unreasonable and it violates the privacy of a person which ought not to be intruded by the state. Ano nga ba ang tinatawag nating probable cause? Probable cause, okay, are facts or probable cause is a set of facts and circumstances as would lead a reasonably discreet and prudent man to believe that the offense charged in the information or any offense included therein has been committed by the person sought to be arrested. So, sa pagdetermine ng probable cause, ang isang average na tao, okay, an average man weighs the facts and circumstances without resorting to the calibration of the rules of evidence, of which he has no technical knowledge. So, sa pagdetermine ng probable cause, gumagamit or we only rely on common sense. Nakalagay sa case ng People versus Gabo, GR number 161083, August 3, 2010. So, the average man will only rely on common sense. A finding of probable cause need only to rest on the evidence showing that more likely than not, a crime has been committed and that it was committed by the accused. Ang probable cause po, it demands more than suspicion. Pero, it is less than evidence. Okay? Doon naman po sa case ng Webb versus De Leon, 247 SCRA 653. Nakalagay po dito, the Supreme Court held that it is or it must be emphasized that ang personal examination is not mandatory and indispensable in determination of probable cause for the issuance of warrant of arrest. So, hindi daw po mandatory ang personal examination ng witnesses. Kailan nagiging necessary? Kailan nagiging kailangan or mandatory? The necessity arises only when there is an utter failure of the evidence to show the existence of probable cause. Okay. Otherwise, the judge may rely on the report of the investigating prosecutor, provided that he likewise evaluates the documentary evidence in support thereof. Lagi niyo pong tandaan na what the law requires as personal examination on the part of the judge is that he should not rely solely on the report of the investigating prosecutor. Sa case ng Okabe versus Gutierrez, sabi ng court, ang judge hindi nagre-rely or hindi niya lang dapat i-consider yung report ng investigating prosecutor. Dapat ay i-go over niya at i-consider din niya yung mga affidavit and documentary evidence ng mga parties. Pati yung counter affidavit ng accused at ang kanyang mga witnesses. Pati na rin yung mga stenographic notes during preliminary investigation kung meron man. Okay? So, if the report taken together with the supporting evidence is sufficient to sustain a finding of probable cause, it is not compulsory that a personal examination of the complainant and his witnesses be conducted. Ano ang pinagkaiba ng isang preliminary inquiry or examination versus preliminary investigation? So, inquiry versus investigation. Anong pinagkaiba? Lagi niyo pong tandaan na merong pinagkaiba ang preliminary inquiry, okay, at saka preliminary investigation. Ano ang preliminary inquiry? Sa preliminary inquiry, it is a stage where we determine probable cause for the issuance of warrant of arrest. Ang preliminary investigation po is yung proper stage, which ascertains whether the offender should be held for trial or be released. The determination of probable cause for the purposes of issuing the warrant of arrest is made by the judge. Ang preliminary investigation proper is the function of the investigating prosecutor. Let's go naman sa method of arrest with a warrant. At saka warrant did not be in possession of the officer. Once na nag-issue ng warrant of arrest ang isang judge, the warrant is delivered to the proper law enforcement agency for execution. So, yung head office na naka-receive or na-issuehan ng warrant of arrest, it shall cause the warrant to be executed within a period of 10 days from its receipt. So, within 10 days, okay, within 10 days after the expiration of the period, yung officer in charge or yung officer na na-assign doon sa execution, gagawa siya ngayon ng report. Magre-report siya sa judge na nag-issue ng warrant. Once na yung officer na assigned failed to execute the warrant, kailangan niyang ilagay sa report niya yung mga rason kung bakit hindi na-execute yung warrant of arrest. That is provided in your Section 4, Rule 113 of your Rules of Court. So, ano naman ang gagawin nyo pag mag-i-issue kayo ng warrant of arrest? Example, si Pedro ay isang pulis. Nahuli niya ngayon si Juan. Okay, si Pedro bilang pulis, siya ang officer na na-assign to execute the warrant of arrest against Juan. Ano ang mga dapat gawin ni Pedro? Okay? So, when making an arrest by virtue of a warrant, si Pedro ngayon, yung officer, number 1, ito ang mga kailangan niyang gawin. Number 1, he shall inform Pedro or the person to be arrested of the cause of his arrest. And number 2, kailangan niyang inform si Pedro kung bakit siya inaaresto. So, he will inform 1 of the fact that a warrant has been issued for his arrest. Once na si Juan, yung inaaresto. Once na si Juan tried to flee, okay, sinubukan niyang tumakas or forcibly resist or giving of the information will imperil the arrest. Okay? Itong tatlong sitwasyon na to. If there is a flee, forcible resistance, or giving information will imperil the arrest. Okay? Magiging dehado yung arrest. Okay? Pag binigay informasyon, then the information need not be made to the person to be arrested. Dapat po bang dala-dala palagi ng officer yung warrant of arrest? Kailangan bang dala-dala niya palagi? The answer there is no. Okay? That is provided in your Section 7, Rule 113. The officer need not have the warrant in his possession at the time of the arrest. So, hindi niya kailangang dala, okay, yung warrant of arrest at the time of the arrest itself. However, tandaan nyo, after ng pag-aresto, the warrant shall be shown to him as soon as practicable if the person arrested so requires it. Lagi niyong tandaan din sa Section 3 ng Rule 113 na yung tao o yung officer na na-assign to execute the warrant of arrest, meron siyang duty, meron siyang obligasyon na dalhin o i-deliver yung naaresto sa pinakamalapit na police station or jail without unnecessary delay. Lagi nyo ring tandaan na sa pag-aresto, pag naging police kayo, okay, in your Section 2 Rule 113, nakalagay doon na dapat walang unnecessary violence during arrest. It is a rule that whenever an arrest is made, okay, there must be no violence or unnecessary force. Okay? There must be no violence or unnecessary force shall be used in making in an arrest. Yung person na arestado, na naaresto, I should say, the person arrested shall not be subject to greater restraint than is necessary for his detention. In your Section 10 naman, nakalagay doon na kung yung officer, let's just say si Pedro, okay, Pedro, the officer, cannot on his own effectively make the arrest. Hindi kayang arestuhin ni Pedro si Juan na mag-isa lang siya. So, Pedro has the authority to summon assistance. Meron siyang authority na humingi ng tulong sa iba. The authority to effect an arrest carries with it an authority to orally summon as many persons as he deemed necessary to assist him in effecting the arrest. Every person summoned by an officer is required to give the assistance requested, provided he can do so without detriment to himself. Lagi nyo ring tandaan na yung the duty of the person summoned does not arise when rendering assistance would cause harm to himself. Paano kung si Juan ay nasa loob ng isang building? Okay? When a person to be arrested is inside a building. Nakalagay sa Section 11 at Section 12 ng Rule 113. Kung si Pedro ay nasa loob ng isang building, or if the person to be arrested or is reasonably believed to be within any building or enclosure. Nakalagay sa batas natin, the rules authorize the officer, si Pedro, that in order for him to make an arrest, pwede siyang mag-break into any building or enclosure in case one or yung person to be arrested refuse admittance after announcing, okay, refuse to let Pedro in. Okay? So, there is a refusal of admittance after announcing the authority of Pedro and his purpose thereof. So, after entering the building or enclosure, yung si Pedro, may likewise break out from said place if necessary to liberate himself from the same place. Let's go naman sa warrantless arrest. Kailan nagkakaroon ng warrantless arrest? Kailan nagiging legal? Kailan nagiging lawful? Okay? Kailan ina-allow? As a general rule, as regards arrest, searches, and seizure, okay, the general rule is that a warrant is needed in order to validly effect the same. Okay? Nakalagay kasi sa 1987 Constitution, the prohibition against unreasonable search, arrest, and seizure. Okay? And this prohibition refers to those effected without a validly issued warrant. So, the doctrine is that a warrant of arrest is required before an arrest is made. So, kailan po nagkakaroon o nagiging valid ang isang warrantless arrest? Tatlo lang. Sa arrest po, tatlo lang. Okay? Warrantless arrest, the pertinent provisions of Rule 113 of the Rules on Criminal Procedure provides for the instances when a warrantless arrest may be made. Your Section 5 provides that or states that a peace officer or a private person may, without a warrant, okay, arrest a person in case of in flagrante, okay, caught in flagrante, hot pursuit, escapee. Okay? Ihe ang shortcut natin dyan. Ihe, in flagrante delicto, hot pursuit, at escapee. Ano yung in flagrante delicto? Okay? In flagrante delicto is when, in his presence, the person to be arrested has committed, actually committing, or is attempting to commit an offense. That is in flagrante delicto. Okay? In flagrante delicto kasi, okay, caught in the act. Okay? So, sa in flagrante delicto, merong tatlo dyan. Committed, actually committing, and about to commit. So, para siyang past, present, and future. So, past is yung committed, present is actually committing, and future about to commit an offense. Okay? Pero kailangan dito, it must be in his presence. Okay? In his presence, dapat nakita niya mismo. Next one is your hot pursuit. Huwag niyong kalimutan yung ihe. Okay? Ihe sa warrantless arrest. Ano naman yung hot pursuit? Meron pong hot pursuit when an offense has just been committed and he has a probable cause to believe based on personal, knowledge of facts or circumstances that the person to be arrested has committed it. Ang importante sa hot pursuit, ito yung hot pursuit is to yung hinuhuli kasi nakita merong probable cause, okay, na he is the one who committed the crime. So sa in flagrante delicto kasi past, present at saka future, ito is past lang yung hot pursuit, past lang plus probable cause. So he has just been committed the offense. So ibig sabihin kakagawa lang, wala pang isang oras nung nangyari yung krimen. Okay? So, and the officer must have the probable cause to be believed based on his personal knowledge na dapat. Okay? That the person to be arrested has committed it. Next one is the escapee. Okay? In your escapee exception, it is one when the person to be arrested is a prisoner na nakatakas sa isang penal establishment, okay? Or isang prisoner who is serving final judgment or is temporarily confined while his case is pending. Pwede ring isang escapee being transferred from one confinement to another. Nakalagay po, okay, that sabi dito sa book, okay, who may make the warrantless arrest? Sino ang merong duty na make ng warrantless arrest? Lagi niyong tandaan na nakalagay mismo sa batas natin, peace officer or private individual. Hindi lang isang peace officer. Example ng peace officer natin, kapulisan. Hindi lang daw kapulisan ang pwedeng mag-aresto. Pwede rin daw ang isang private person. And we call that the citizen's arrest. So what is the basis for the so-called in flagrante delicto? Okay? Lagi nyo pong tandaan sa in flagrante delicto, the person to be arrested, doon sa case natin si Juan, ang aarestuhin ni Pedro ay si Juan. Si Juan, napatay niya si Maria. Okay. The person to be arrested must execute an overt act indicating that he has just committed, okay, is actually committing or attempting to commit a crime. At dapat itong overt act na to is done in the presence or within the view of the arresting officer. So, ano bang tinatawag nating in flagrante delicto? In flagrante delicto means caught in the act of committing a crime. The rule which warrants the arrest of a person without a warrant requires that the person arrested has just committed a crime or is actually committing or about to commit the crime. And it must be within the purview or within the view or the presence of the arresting officer. So we go to the method of arrest without a warrant. If the arrest is made by an officer, when making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and the cause of his arrest. Lagi niyong tandaan na kung yung taong aarestuhin is engaged in the commission of the offense or is in the process of being pursued immediately after its commission, or he tried to escape or flee or forcibly resist, Okay? And when the giving of such information will peril the arrest, then the information need not be given. So, ibig sabihin nito, the officer may summon, okay, assistance to effect the arrest. He can likewise break into the building or enclosure or break out from the same. And so if you will effect naman citizen's arrest, okay, if or when a private person makes an arrest, ang kailangan niya namang gawin ay he shall inform the person to be arrested. Not of his authority, syempre. Pero ang kanyang intention to arrest him and the cause of his arrest. Okay? And of course, the private person also has the right to break into a building or an enclosure. Specifically refers to an officer and not to a private person. Okay? The right to break into a building or enclosure refers only to an officer, hindi sa isang private person. Kailan po pwedeng mag-make ng arrest? What is the proper time of making an arrest? Lagi niyong tandaan in your Section 6 Rule 113 that an arrest may be made on any day at any time of the day or night. So, pwedeng umaga, pwedeng gabi, at kahit anong oras po. Nakalagay sa Section 6 Rule 113 of your Rules of Court.